Okay, hello, hopefully you can hear me. This is the court case of West Virginia State Board of Education versus Barnette, 319 U.S. 64 in 1943. This is a Pecha Kucha by Brett Bentley. The date is April 21st, 2021. This is for EDU 306, School Law and Advocacy K-12 learners. So, first we have our plaintiff, the children Marie and Gauthy Barnette, in a family of Jehovah's Witness. And Jehovah's Witness is a Catholic creed/religion that believes that Jehovah is their God. And in the 1930s, the government of Nazi Germany began arresting thousands of Jehovah's Witnesses who refused to salute the Nazi flag and sent them to concentration camps. As a result, Jehovah's Witnesses believe that the obligation imposed by law of God is superior to that of the laws enacted by government. And this is basically saying that the Jehovah's Witness, if their government goes against their law or their rule, they should not follow that law or rule. And this will relate later on. Now the defendants, the West Virginia State Board of Education, this board was present in the 1942, well, this specific board was present in 1942 for this case. Now following a previous case, the Minersville School District versus Gobbets, in 1940, following that decision, the West Virginia legislature amended its statutes to require all schools in the state to conduct courses of instructions in history, civics, and the constitutions of the United States and of the state. So this is basically saying that they want more civil and more history-based stuff inside of their classrooms. And as you can see, they have the students say the pledge every single morning. And this is one of the things that they ruled in there. They want the schools to do this. Now the facts of the case, part one, are that West Virginia Board of Education adopted a measure requiring that all public school students salute to the flag and recite the Pledge of Allegiance. Every single morning, every day, they want them to do this. And if students did not participate, they could be expelled and their parents could even lose custody of them if the situation is dire enough. This is an extreme policy, and this leads to why this case is happening in 1942. The facts of the case, part two, on the other side, a group of Jehovah's Witnesses challenged the law on the First Amendment grounds. They believe that the forced flag salute conflicted with their religious beliefs against idol worship and graven images, and therefore violated their free exercise of religion and freedom of the speech rights under the First Amendment. This is basically saying that because of their previous history with Nazi Germany, they elect to not do what the government tells them to do if their religion conflicts with it. And in this case, they don't want to pledge allegiance to the flag, so they don't do it, and this conflicts with the school rule. Now, what is the issue? What the Jehovah's Witnesses, what the two kids are arguing for, are that whether school officials violate the First Amendment by forcing students to salute the flag and recite the Pledge of Allegiance. The arguments made by the court, while this went to the Supreme Court, the board's argument was that the plaintiffs, the Jehovah's Witnesses, raised no substantial federal question, and the brief relied extensively on Justice Frankfurter's Gobbets' opinion. So they're relying on this guy's previous decision from Gobbets. This Gobbets case relates to this case a lot, so they're looking to him for it. The American Bar Association's Committee on the Bill of Rights and the American Civil Liberties Union filed amicus briefs that argued Gobbets was bad law and should be overruled. Basically, what they're saying is that they don't believe that the previous case, the Gobbets case, was justified at all, and they believe that it should be overruled in this case. The final decision by the 9 justices was a 6-3 vote. The court held that the school officials do violate the First Amendment by compelling students to salute the flag and recite the Pledge of Allegiance. So we have Stone, Black, Douglas, Murphy, Jackson, and Rettlug, all four, and then Roberts, Reed, and Frankfurter, who is along with the case on Gobbets, against it. The reason for their vote was the First Amendment prohibits government officials from compelling individuals to speak or espouse orthodox beliefs that are at odds with their conscience and values. So they're ruling that because Jehovah's Witness has their rules against this, they believe that they should be prohibited from their governmental officials. The purpose of the First Amendment is to ensure that the individuals have an individual sphere of freedom and thought and belief that the government cannot invade. So, the school violated the First Amendment in the justice's eyes. Now, a quick quote by the Court Justice of Justice Robert Jackson. He was for Barnette. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion or force citizens to confess by word or act their faith therein. Now, on the other side, Justice Felix Frankfurter was quoted as this: an act compelling profession of allegiance to a religion, no matter how subtly or intentionally promoted, is bad, but an act promoting good citizenship and national alliance is within the domain of governmental authority and is therefore to be judged by the same considerations of power and of constitutionality as those involved in the many claims of immunity from civil obedience because of religious sculptures. So, in the aftermath of all of this, the majority opinion of Barnette is considered one of the court's greatest and most sweeping statements about the fundamental freedoms established by the Bill of Rights. The case not only dealt with the free exercise of religion from the Jehovah's Witness, but also the finer details of the First Amendment. After Barnette, the court began to turn away from the belief action doctrine altogether, creating a religious exemption for believers of different creeds and religions.